We're going to have a conversation about the courts in America and also about what's happening at law schools across our country. I've got Ilya Shapiro here. Hi, Ilya.
Good to be with you.
Thank you for making time for us today. My boss, Kelly Shackelford, has been saying for the last year or two that thanks to recent Supreme Court decisions, Americans now have more religious freedom than we've been able to enjoy in our lifetimes. We have to go enjoy it, but as far as the courts have set it up, we have more freedom. Do you agree with that assessment? Is that where we are?
I think that's absolutely right, whether in the context of education, whether it's in the context of expressing yourself in public, whether it's in the context of you're a religious organization and you're applying for a general public benefit. There have been rulings, correct rulings by the Supreme Court that have advanced religious liberty in that regard. And other liberty, I should say. The court in general has been very strong.
Yeah. This is an interesting time in our country with all those changes taking place. As you look across the courts in America, because I know you spend time just analyzing judicial nominees and who's coming up and who's been named to the courts. Where are we as a country as you look at the appeals, particularly the appeals courts? What do you see right now? Are we in a good place?
The longest lasting, most impactful actions by President Trump in his first term are probably on the judiciary, on the bench. 54 circuit court appointments, just one shy of Obama in 2 terms.
Yeah.
And these are not just run-of-the-mill lawyers. These are smart, courageous people, originalist, textualist, leaders, influencers on the bar, and they are having an impact on courts all across the country. So it's not just the Supreme Court. We've seen a transformation of the lower courts, which is now continuing into Trump's second term, although fewer opportunities for appointments, just the way that the vacancies play out.
And that's a legacy that lives on beyond any particular administration. It goes on for a generation, right?
Long after a president has left the White House, decades later, the judicial appointments that he's made are still there, affecting our landscape. President Reagan appointed Justice Scalia, who was the bridge to the 21st century.
And my favorite Supreme Court justice, but yeah.
There you go. I mean, these things, the lower courts as well. Again, decades they're there. Even as executive appointments obviously end when the presidential term ends, legislation can be changed. Guidance documents aren't worth the paper pixels they're printed on. Regulations rescinded, all that. Yeah. But judges are there for life, for decades. So this is a very important thing. And President Trump has continued in this second administration to select people who are smart and courageous and are going to do that job to uphold religious liberty and federalism and our constitutional order.
Many Americans, the most they know about the court system, they only think of it what they see on a crime drama and everything's solved in 54 minutes or so. When you look at nominees to the bench, what do you look for? What's, in your estimation, from your point of view, what makes for a good judge?
So I don't look at whether they've been donating to Republicans. I don't look at whether they've been members of the Federalist Society. That's such a low bar. I look at what is their paper trail. What have they written, whether as academics, whether as lower court judges, as practicing lawyers? What kind of cases have they taken on pro bono? Yeah. Not in terms of they're a big firm, what pays the bills, but what have they taken on that they didn't have to take on? What slings and arrows did they face? Have they ever taken positions publicly that would subject them to criticism, and have they faced that criticism rather than shying away from it and taking the road that's easier? Are they not just sound good or said good things, but where is the evidence that they're pushing back on the administrative state, that they believe in religious freedom, in economic liberty, in school choice, and giving parents more freedom? All of these different issues that are so important, on pushing back on federal power instead in favor of the states. What did they do during the pandemic? Yeah. Did they take any positions that were public, one way or another, in whatever job they had? Because it touched us all. So I want to see evidence of intellect, evidence of good, sound legal theory, and the courage of their convictions.
You used the terms originalist and textualism just moments ago. Define those for us. When we throw them around a lot, but we don't stop to think what that actually means. What do they mean?
These terms didn't used to be controversial. Originalism just means interpreting the Constitution so that each provision means what it meant when it was enacted. The original public meaning of those provisions. Congress has the power to regulate interstate commerce. That means Congress should not be regulating a mom and pop shop on your local corner there. That's not engaged in interstate commerce. Yeah. Reasonable expectations, certain no warrantless searches, all of these terms that they can affect, whether in the context of separation of powers, what's the legislative power, what's the executive power, what's the judicial power, enforcing that constitutional rubric. Textualism is related. It relates to statutes, federal laws that are passed. Do they apply the text of the statute rather than looking at what they think, what did Congress really intend? Mm-hmm. Who cares what the words say? Let's get in the minds of Congress and do what we think they intended, or what will be justice. That's kind of a more woolly, result-oriented jurisprudence that I think we want to avoid, because judges are very powerful, but their power is restrained to enforcing what the law actually is. And in the federal system and in some state systems, they're given lifetime appointments so that they're insulated from political pressures, so that they can sometimes take decisions that might not be popular, but they say, look, my hands are tied, because that's what the legal text says, that's what the constitutional text says.
There's something that sounds ridiculously simple, but it's essential to a nation of laws, and that is that words have meaning. And each word in a law, like you were just talking about, has a meaning to it. And we saw during the Obama administration, he decided, we'll just change the meaning of some of those words and change the entire impact of the law.
Or say, try to forgive student loans after Congress rejected that by having nonsensical readings of existing statutes, and the Supreme Court slapped that down and said, well, I'll try it some other way. I mean, that's not upholding the rule of law. So judges should be there to, hold political actors' feet to the fire, and any judicial candidate, heck, any law professor with any integrity should be able to answer the question, what's a constitutional or a statutory interpretation that you have that goes against your policy preferences?
Over the last 4 or 5 years, we've had a number of Supreme Court decisions that have really changed the landscape of how the courts look at religious freedom in particular. What stands out to you? Which ones would you put at the top of your list as far as changing the landscape of America?
There's a trilogy of public school cases where the court has said, look, if you make a particular benefit available, parents can use this funding to take it to private schools or tutors or whatever the case might be. And then they said, but you can't use that for religious education.
Right.
Well, that's not fair. Either you have the program and the parents are allowed to take that wherever, scholarship granting organizations can give that to kids going to whatever school, or don't have the program in the first place. But don't discriminate and say secular schools are okay, religious ones are not. There's a case this term, kind of on the flip side, in public schools with an opt-out. There was LGBTQ type storytelling, instruction, books, things like that, not in the sex ed curriculum where there's opt-outs across the country. But they were integrating this in the language arts curriculum that didn't have an opt-out, or at least they did originally, but then in 2023, the school board, this is in Montgomery County, Maryland, a big populous suburb of DC, they said too many parents are opting out, so we're going to kill the opt-out. Well, now, I might think if too many parents are opting out, maybe you want to reevaluate the curriculum, right?
One would think.
One would think. But no, they just killed the opt-out, and they're the only jurisdiction in the entire country. That's how much of an outlier they were that wouldn't give parents the opt-out for some of these controversial, sensitive, religion-infringing instructions. And the Supreme Court got rid of that, said, no, you can't operate that way.
And parents need to know that's not accidental. That's part of a long-term strategy, a decades-long strategy to put activism into curriculum outside of sex ed, all the way down to the kindergarten level.
Yeah, and here the parents, it was a very good PR strategy in addition to a good legal strategy, because the parents who were suing was like one of those coexist bumper stickers. There were Muslims, there were Orthodox Christians from Ethiopia, there were Jews. I mean, like all these religions represented, saying, look, this goes against our religion. And they weren't saying get rid of these books out of the school library. They're just saying notify us, let us opt out so our kids aren't being exposed to this. So really an unreasonable position that the school board was taking.
You've got a book out called Lawless, The Miseducation of America's Elites. We've talked about the courts up to...
And that was the subject of my previous book, Supreme Disorder, which is still in print, paperback edition, about the politics of judicial nominations in the Supreme Court. But yes, my new book that just came out earlier this year about the perversion of our law schools and what that means if we don't fix it for our legal system going forward.
Because that's where the attorneys and the future judges come from. So what are you seeing changing on campus? What is different now than it was not that many years ago?
So I graduated law school 21 years ago, which sometimes feels like just yesterday, and sometimes feels like, ages ago in a galaxy far, far away. What I want to make clear is that what I detail, failures in bureaucracy, in leadership, and ideology, this is not just the latest iteration, the latest chapter in a decades-old conservative complaint about liberal bias in higher education. This is not the Berkeley hippies taking over the faculty lounge. Heck, the radicals now would call those hippies retrograde white supremacists.
Yeah.
It's really this postmodern illiberal takeover of higher education, and specifically legal education, that's worrying, because they contend not simply that originalism is bad, we need a living constitutional theory, or we prefer left-wing policies to right-wing policies. They're saying entirety of the law is illegitimate. All of our institutions are illegitimate because they're irrevocably imbued with racism and sexism and patriarchy and all of these different things.
Is that coming from the professors? Where's it coming from?
It's coming from all over the place. So yes, the faculty is a problem, but the bureaucracy is an untold story. We've had an explosion of non-teaching staff at all universities and including at law schools, and they've become the tail that wags the dog. The DEI offices in the last decade, but student support and others that are not trained in academic norms of academic freedom and free speech, the classical liberal stuff, equal protection, due process. I'm not talking about any conservative policies or views. I'm talking about just very basic, the core mission of any university, of any law school, to teach lawyers to uphold the rule of law. These folks now are saying instead, no, these structures are illegitimate. They need to be rebuilt according to privilege hierarchies. Your rights and freedoms depend on where you are in an intersectional matrix. It's philosophical mumbo jumbo, but it's dangerous because this is what's getting taught, and this is sort of the peak woke that we've recently lived through. I'm optimistic about society writ large, but in terms of academia, in terms of law schools, we're still very much in the eye of the storm.
And it's not America. I mean, that's what you just described is not the experiment that our founders set on its way 250 years ago. That's a whole different society.
Well, the founders were all, rich, white, cis heteronormative slaveholders.
He said sarcastically.
Sarcastically, we shouldn't listen to them. I mean, that's I mean, when you say the whole system, the whole country is illegitimate, that's what it means. Again, this is not some baby boomer 1960s or 70s liberal, ACLU, card carrying, whatever. No, this is burn it all down. We need to change it across, anti-racist, all of the jargon that you see occasionally that's migrated from the sociology departments, the postmodern philosophy into these practical things. When I was in law school, we had heard about critical studies, right? Critical race theory, queer theory, all of that sort of stuff. But that was something from the 80s and 90s, some relic of the past that had been relegated back into some niche corner of comparative literature or something like that. Well, that's roared back with a vengeance. And it's been empowered by these explosion of bureaucrats and then facilitated by weak leaders. And most leaders, law school deans, university presidents, are not themselves woke radicals or social justice warriors. They're spineless cowards. And that's a problem because they've been kowtowing to this illiberal growth.
And the book, again, is called Lawless, The Miseducation of America's Elites. Final question for you. We're at a religious liberty conference with leaders from all over the country talking about this. Why does that matter to you? Why are you here?
It's funny. I joke that I'm the favorite secular Jew of a lot of religious liberty organizations. I'm not a regular synagogue goer, but especially after October 7th, I've become much more in touch with my heritage and my Jewish culture, and more deliberate about how I educate my children in that way from a tradition and faith perspective. But religious liberty is always, when you look historically, when people are oppressed, religious liberty is one of the first, if not the first thing that goes.
Every time.
It's just like with anti-Semitism now, we have more anti-Semitism than we've had in decades in this country. And anti-Semitism obviously is bad, but it's the canary in the coal mine. It reveals all sorts of underlying pathologies, whether in the higher education context, that means cancel culture and intellectual corruption, all these things, whether in society writ large, that means lots of other things that are being attacked. The foundations of our basic rights and liberties, of our American prosperity. And so that's why religious liberty, more broadly than just anti-Semitism, is a canary in the coal mine for all of our liberties.
Ilya Shapiro, thank you so much. Always good talking to you.
Great to be here. And you all do great work. I love this conference, and it really enthuses me for the year to come.